Can you get bail during a criminal appeal? Imagine being convicted of a crime and wondering if you can leave jail while fighting that conviction. It's a question many defendants ask when they want to stay involved in their case. Getting bail during an appeal is possible, but it's not automatic. Whether you can get out depends on the laws of the state or federal court handling your case. Usually, after a conviction, the right to bail is not guaranteed, especially for serious crimes like felonies. Courts have discretion to decide if bail should be granted. Bail during an appeal means you are released from custody while your case is being reviewed. It's different from bail before trial, which is more common. After a conviction, bail is harder to get because courts worry about flight risks and safety concerns. Courts look at several factors when deciding whether to grant bail during an appeal. They consider if the defendant might run away to avoid serving the sentence. They also evaluate if the person poses a danger to the community. The strength of the appeal matters too. If the appeal has a good chance of success, courts might be more willing to grant bail. Other things courts examine include how connected the defendant is to the community, their criminal history, and whether they have followed court orders in the past. The length and seriousness of the sentence also influence the decision. For example, if the crime was very serious or the sentence is long, bail is less likely. In some states like California, there are laws that give courts the power to decide on bail during an appeal. The defendant must file a motion asking for bail, and then a hearing is held. The court will decide based on the evidence, including whether the person is a flight risk or danger. They also look at the merits of the appeal. In federal cases, the rules are stricter. The United States law says there is no automatic right to bail during an appeal. The defendant must show that their appeal raises a significant legal question and that they are not a risk to flee or harm others. Courts tend to be more cautious with federal appeals. From a defense point of view, it's important to carefully evaluate if seeking bail makes sense. The lawyer will gather evidence to show the defendant's ties to the community, lack of danger, and the strength of the appeal. If bail is set too high, they can ask for a reduction. Being out on bail during an appeal can help the defendant stay involved in their case, maintain their job, and support their family. It also allows them to better prepare for their defense. In summary, getting bail during a criminal appeal is not guaranteed but can happen if the court believes the defendant is not a flight risk, is not dangerous, and has a strong appeal. The decision depends on many factors, and a good lawyer can help present the best case for releases.